ADA Patsy, are you on?
Yes, I am.
Okay. How many officers are there signed in?
Well, right now there are 3. And actually, Attorney Malos and I were discussing this earlier this morning. I definitely intend to call Officer Corin and Officer Delsart. I guess looking at the defendant's motion, it appears the challenge is to, well, it seems like they're saying that the defendant was in custody before we are. So there's a custody issue, and then any statements that the defendant made. I do have Officer Linsmeyer here as well. He, though, is the one who read the defendant, the informing the accused, and also had conversation, apparently, when the defendant asked where he was, and Officer Linsmeyer informed him he was in Green Bay. So his testimony would be very, very limited. So
Okay.
that's what I have.
Put them in, everybody who's possibly going to testify, I put in the breakout room.
Okay.
And then Ozaukee County Jail, are you there?
Yes, I am.
Okay. And you're Mr. Bultman?
Correct.
We can hear you, but we can't see you.
Let me see if this will.
Okay, now we can see you. I'll call the case. This is Brown County case number 19 CF 1819, State of Wisconsin versus Jacob Robert Bultman. The state is here by Assistant District Attorney Amy Patsky. Attorney Corey Malos is here. Mr. Bultman is appearing by video from the Ozaukee County Jail. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. We are here today on a motion to suppress evidence filed by Attorney Malos. And before we get started, there is an aspect of this case from reviewing the criminal complaint that's sometimes overlooked from my experience, and that's that there was a warrant for his arrest in this case. That's what it says in the criminal complaint anyway. And just so the parties are aware, that does change the constitutional analysis. I didn't see any reference to it in Attorney Malos's motion, but in Utah v. Streiff, it basically says that if there's a valid warrant for an arrest, it attenuates even unconstitutional contact by the police officer. Attorney Malos, is that a case that you're familiar with and that you analyzed before filing the motion?
In fairness, Judge, I am familiar with the legal principle. I have not read that case, so I would agree with the court on the holding being an accurate representation of the existing law. I think that some of the question then relates to the search of the vehicle and whether that essential search of the vehicle would have been lawful at the time.
Okay, and just based on the criminal complaint, that's all I have in the case. If he has a valid warrant, no matter what happens with this contact with police officers, he's going to be taken into custody on the warrant, and then he's basically got a vehicle that's stuck in the middle of the road, unoccupied.
And I get it. The other thing I'm wondering too, Judge, is at what point law enforcement would have become aware of that. There are certain series of cases that suggest that.
Well, this is a U.S. Supreme Court case.
Yeah, and does that say that even if law enforcement took him into custody without, at the time, knowing the warrant was legal, that would excuse any unlawful Fourth Amendment issue?
I haven't read the case in a while. It's a 2016 case, so it's not that old. but I think that's holding in Utah v. Streif addresses, yes.
Do you mind if I just read that for a few minutes, just because that might narrow the scope of the issues?
Okay.
And how do you spell Streif?
STRIEFF, I believe.
Right. And Judge, I apologize because I'm doing a quick reading here, but I think that if I read Streif correctly, the court is saying that the attenuation analysis still applies, meaning that the court still has to go through the factors on whether law enforcement's conduct would be subject to the exclusionary rule. And here they're saying that the arrest was made pursuant to a lawful warrant. So, and then it applies three factors on the attenuation analysis. So I think the court still has to do the analysis, if I'm not mistaken, including looking at the flagrancy of officer misconduct, if there is flagrant misconduct, temporal proximity, and then also, I always forget the second factor, intervening circumstances. And I think that would be the rest. And that's kind of why I was pointing out the time in which law enforcement would notice the warrant, I think would be a material factor under the second part of attenuation, because if they didn't discover that till long after the arrest was made, I think that would militate in favor of finding that there wasn't intervening circumstances. And then on part 3 of attenuation, it might also suggest that there might have been some misconduct. Whether that's sufficient to attenuate or not is, I guess, the question for the court. But that's just how I'm reading it right now.
Okay. I don't think that's exactly what it says. I think the ruling is much more general, that if there's a warrant for the arrest, as long as there's not police misconduct, that it attenuates even an unconstitutional initial contact with the officers. And that the point that they know that there's a warrant is not relevant.
Yeah, maybe I should read this longer, but I think on page 2063, I believe this would be the majority. It says the outstanding arrest warrant for Strief's arrest is a critical intervening circumstance that is wholly independent of the illegal stop. The discovery of that warrant broke the causal chain between the unconstitutional stop and the discovery of evidence by compelling Officer Fackrell to arrest Strieff. And it is especially significant that there is no evidence that Officer Fackrell's illegal stop reflected flagrant unlawful police misconduct. And so I think Justice Thomas, as I'm getting it, I think that's post-attenuation analysis of the 3 factors. He's really making that conclusion. And in the first paragraph, he says, we hold that the evidence the officer seized as part of the search incident to arrest is admissible because of the officer's discovery of the arrest warrant attenuated the connection between the unlawful stop and the evidence seized incident to arrest. And just above that, I think it comments that the question in this case is whether the attenuation doctrine applies when an officer makes an unconstitutional investigatory stop, learns that during that stop that the suspect is subject to a valid arrest warrant, and then proceeds to arrest the suspect and seize incriminating evidence during a search. And then I went down, it looked like, I think this would be the 3rd paragraph. It says, as part of the stop, Officer Fackrell requested Strieff, STRIEFF''S identification, and Strieff produced his Utah identification card. Officer Fackrell relayed Strieff's information to a police dispatcher who reported that Strieff had an outstanding warrant for a traffic violation. Officer Fackrell then arrested Strieff pursuant to that warrant. So that is my reading, Judge. And in fairness to the court, I am just reading this, but it seems that the intervening fact there is actual dispatch confirmation that there was a pending warrant. And I think it's material that the arrest was made there pursuant to the warrant, because I think that essentially says that the officer in his mind at the time made a good faith arrest that would essentially negate some of the exclusionary principles. So that's how I would read it, but I really haven't, in fairness, read the whole document. I would think that in some cases, for example, on OWI's 3 versus 4, I think there is some case law that the officer didn't know at the time that the legal standard was 0.02 and thought it was 0.08. It would be material that the standard essentially would be 0.08.
But in terms of his arrest, though, Utah v. Strieff is pretty clear that none of that's going to make a difference when they run his driver's license and find out that he has a warrant. He's going to be arrested on that warrant.
And the question in my mind would be that,
and I think as soon as he's sitting alone in a vehicle in the middle of an intersection, according to the criminal complaint, and if that's the case, I mean, they're 100% within their right to at least run his driver's license.
Sure. I think it comes down to a Rodriguez analysis, and yes, typically they can always run the license, but then the question is when they learn that information, is it at the point when the traffic stop should have discontinued? And I think that requires some testimony to figure out when they learned that information and see if it would have been inside the scope of what should have been the original traffic stop, what would take an officer a reasonable amount of time to conclude mission 1 of the traffic stop. It seems like they're doing a caretaker analysis. They see him pursuant to some type of caretaker call. He seems out of it, and then they're trying to step 1, figure out who he is, and then figure out if he needs some type of medical care. And then as part of that process, I think they can certainly do that background. The question is when they learn the information, and would that still fit within the scope by the time they learned it, or should he have been free to leave at that point? And so
Okay. Well, my only point was that you're aware of the case and can you know the facts of your case better than I do, of course, because I only have the criminal complaint, but that you did fully consider that and still want to go forward on the motion.
You know, Judge, I'll be fully honest. I must have overlooked that in the complaint because I was watching the body cam. The squad camera and reading reports, and so that's a question of when the warrant did come up. In my mind, is still material. I do fully agree with the court that that is certainly a factor that the court is required to consider, and I think that comes under the attenuation test. And I think if it's a straightforward case, yeah, I think that it's more like Streif, but I think that always comes down to the totality of the facts.
Okay, so you do want to proceed with the motion here today?
Yeah.
Okay. Then I'm gonna put the officers in the breakout room.
And Judge, just so the court is aware, aside from all of that, I can tell the court that I anticipate the testimony will be that they're also investigating an OWI, and Officer Delsart obtains consent to search the vehicle as well. So, there are multiple theories, or at least those two theories, in which officers can search the vehicle.
And then I believe there's 3 officers, so I'm putting you in a breakout room right now. Please, if you get an indicator on your screen, please accept it to go into a breakout room and do not hang up.
Judge, do you want to, I'll call Officer Coran first. Do you want to keep her out of the breakout room?
Oh, Officer Coran, if you could not accept the breakout room invite, if you're going to be called first. And then Officer Delsart and Officer Linsmeyer, you can accept the breakout room. Then Officer Coran, if you want to turn your camera on, so we know you're there. Okay. Wait for Officer Linsmeyer and Officer Delsart to go to the breakout room.
Your Honor, I have not got an indicator yet.
Oh, you haven't?
I haven't either.
Okay. Well, let me see what I did wrong here. Okay, did you get the indicator now?
Yes, sir.
Breakout room procedure is now in effect. And then they can call their witness.
Thank you, Your Honor. I would call Officer Coran.
If you could please raise your right hand. You do need to unmute your device. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you state and spell your full name, please?
Shawna Coran, SHAWNA CORON.
Before we start the questioning, how are we going to handle exhibits if there are going to be any?
Your Honor, what I did just before zooming in, I forwarded a copy of Officer Coran's report to the clerk. I asked that it be printed and marked as Exhibit 1. And then I also included on that email the alcohol drug influence report as Exhibit 2. And lastly, as Exhibit 3, Officer Delsart's report. Basically, Your Honor, because we're doing this by Zoom and not in person, if the officer will need to refresh her recollection, or Officer Delsart, when he's on the stand, his recollection, I would ask that they be allowed to refer to those exhibits. I did include them, as well as Attorney Malos, on that email. So at this point, unless Officer Coran needs to refresh her recollection, I won't need to use it, but but if she does, then we have it.
And Attorney Malos, are you tracking on what the exhibits are? And do you have copies?
I believe I just heard exhibit 1 is Officer Corin's report, 2 is the alcohol assessment, and then 3 would be Officer Delsart's report. And then I do have all those.
Yes, that's correct. Okay,
Great.
then the state can commence questioning.
Okay, and again, just so I know the scope of this motion, it's at what point was the defendant in custody, and then and any of the statements pre or post Miranda is what the defense is looking to suppress.
Yes, and I'm glad you mentioned that because I was just going to clarify. Really, there's a 2-part challenge, and this really relates to the early activities in the stop. And I think that would predate any consent after the fact, and there might be an attenuation analysis on the consent then. But as far as as far as one case I referenced in the motion, it was the State v. Dobbs case, and I believe that was the series of Wisconsin cases that deals with when a police officer takes a suspect and transports them some physical distance. The question is whether that would essentially create a type of a seizure that would require probable cause, more similar to an arrest. So I'll flesh that out more, but I basically think what we're dealing with it just factually is really up until the point where Mr. Boltman would have been handcuffed essentially outside the squad car. And basically the 2 questions in my mind would be, number 1, whether he would reasonably believe he was in custody for the purpose of Miranda, and that would trigger the need for warnings for inculpatory statements, but also whether essentially there was a de facto arrest that would have occurred based on him being handcuffed incident to the traffic stop before he was transported for field sobrieties. That's really the scope of what we're challenging. And my understanding is under Wisconsin case law, and I think this is mirrored with the federal case law, police can't do a de facto arrest. And it's a totality of the circumstances analysis of how far he was transported, what was the reason for the transport, and whether under the circumstances, it would suggest that the person was being arrested and whether there was probable cause to support the de facto arrest.
All right, well, I think several things are going on here. I know that under Wisconsin law, officers can, number 1, need reasonable suspicion to make contact or stop a vehicle. And then under OWI law, they can transport a suspect to do field sobriety tests elsewhere, and that's ruled not in custody. But I think at the similar time, there's the finding of the large amount of meth in the vehicle. So I guess we can flesh that out with testimony.
Yeah.
All right, Judge, should I just begin the questioning then?
Yes, please.
Okay, so first, Officer Corin, I don't know, did the clerk swear her?
Yes.
Yes, okay. All right, would you state your occupation?
I'm a police officer with the city of Green Bay.
And how long have you been so employed?
A little over 2 years.
Primarily, what are your duties as a police officer?
I work the night shift, so I patrol the city of Green Bay in different districts. I drive around, I respond to calls, or I complete traffic stops or look for suspicious vehicles.
Directing your attention to November 21st of 2019 at approximately 1:41 a.m., were you on duty?
I was.
Okay. And at that time, do you recall where you were?
I don't exactly recall, exactly in the city where I was, but I was in our David district, which is far east of the city of Green Bay.
And At that time, approximately 1:40 a.m., were you called to check the welfare of someone at East Mason and Erie Road?
Yes.
And at the time, what was your understanding of what was happening at that scene?
That there was a car either parked or stopped in the middle of an intersection with a male passed out behind the wheel. Or somebody passed out behind the wheel.
And did you respond to that intersection?
I did.
Did you find any vehicle?
Not at that intersection, no.
So what happened?
I continued a little bit further east on East Mason to the intersection of, I believe it's Grandview, and located the tan vehicle that was given in our description over dispatch, parked in the middle of East Mason.
And that location, East Mason and Grandview, is that in the city of Green Bay, Brown County, Wisconsin?
Yes.
All right, could you describe your observations of the tan vehicle, other than it was parked in the middle of the road?
I believed it was parked because there was no brake lights on. Usually when we come across, obviously a vehicle in the middle of the intersection, usually the brake lights are on, but there's no brake lights. And I observed somebody passed out behind the wheel.
And were you alone or were you with another officer?
Officer Delsart came to back me up.
So what did you do when you noticed the person passed out behind the wheel?
I approached from the passenger side. Officer Delsart approached from the driver's side. Again, I noticed he was passed out and I wanted to turn the car off. That's just normal in OWI when we come across somebody that's either parked or in drive, to go in if the door's unlocked and to take the keys out so that person doesn't drive away.
Did you, in fact, confirm that the car was in park?
Yes.
So were you able to successfully turn off the vehicle and take the keys out of the ignition?
I at least turned off the vehicle. I would assume I took the keys, and I'm not sure if that's in my report, but.
And would you recognize the driver?
Yes.
Okay.
We'll stipulate to identify for today's hearing.
Can you repeat that, Attorney Malos?
Yeah, we would stipulate to identification for today's hearing
Is it for all three officers, or how many officers are going to be called?
for any officer.
Okay, thank you. Then the stipulation is in the record.
Thank you. And when you saw the defendant, could you describe his condition?
He was like slumped over the wheel, appeared to be passed out and or sleeping.
And what happened as you were turning off the vehicle?
He woke up and noticed officers, was very surprised to see us. I believe he started moving his arms around a little bit, and I believe both myself and Officer Delsart told him to relax.
At any point, did you identify him?
Not at that point, no.
And what happened after you said you and Officer Delsart just told him to relax? What happened next?
I went over to the driver's side, and Officer Delsart pulled him out of the vehicle, patted him down for our safety because we didn't know if we had any weapons on him. And then Officer Delsart walked him to the front of my squad.
And at this point, did you talk to him about what's going on, or why is he parked in the middle of the road?
Yeah, so I want to add in something. When we were at the front of my squad, he still had his arms behind his back because Officer Delsart had patted him down. We even told him, hey, relax, man, you can put your arms down at your side. And then, yes, we started talking to him about where he was coming from, why he's parked in the middle of the road. Was he on any drugs, alcohol, which is standard procedure for an OWI.
And did you initially suspect that he was under the influence of some either alcohol or drug?
Yes.
And at this point, why did you suspect that?
Normal people don't park their cars in intersections, random intersections. And his eyes were, I believe, bloodshot and his speech was slurred. And then he also told us, once we asked him if any drugs or alcohol were in his system, he admitted to drugs.
Did you notice the odor of alcohol about him at all?
No odor of alcohol.
Did he did he tell you what type of drugs he was using?
I don't believe so.
Do you recall if you specifically talked to him or if Officer Delsart did?
It was both of us. So Officer Delsart, I think, asked him if he had drugs, and I believe he said some drugs. And I was like, so you have, I think I asked him again. I said, so you took drugs? And he said, yes.
Do you know if Officer Delsart asked him if the defendant took meth?
I don't recall.
Okay. Now, what did you do next after you had this conversation with the defendant?
Discussed with Officer Delsart that if we were going to do the standard field sobriety testing, that it would need to be done at the hospital, which is what we do in inclement weather. It was like raining, sleeting that day. So I believe we handcuffed him and put him in the back of my squad to transport him to Aurora for standard SFSTs.
And SFSTs are standardized field sobriety tests?
Yes.
Approximately how far is Aurora Hospital from the intersection of Grandview and East Mason?
Less than 10 miles. It's like a 5 to 10 minute drive. It's not very far away.
Okay. And why is it that you wanted to conduct the field sobriety tests?
To see if he was under the influence of alcohol or drugs.
And are those a tool to help you to determine that?
Yes.
So what did you do after you informed him about that transport to Aurora? What happened?
I believe Officer Delsart gained consent from the defendant to search his vehicle. And when he went and searched his vehicle, he found what we believe to be crystal meth in a cup in the cup holder, and he showed me. And then he called a supervisor and told me he would meet me up at Aurora once he was done with the vehicle.
Okay. And at any time had you talked to the defendant to ask him, you know, where he was coming from?
Yes. So when we pulled him from the car and had him stand in front of my squad, that's when I asked him where he was coming from.
Do you recall what he told you?
Said he was coming from Milwaukee.
And at the time of your contact with the defendant on scene at that intersection, did the defendant ask where he was?
I believe so, yes. And I told him that we were way off the highway if that's where he was intending to be.
Did he have any idea as to where he was?
No, he had no idea.
Was he confused as to where he was?
Yes.
And did he appear to be under the influence of a controlled substance at this point?
Yes.
All right, so you said that at some point Officer Delsart had obtained consent to search his vehicle. Do you recall approximately where that was in the contact with the defendant?
I'm not sure.
Okay. Did you at any time run his name with dispatch?
I think once I put him in the back of the squad, then I ran his name over dispatch.
And did you learn anything about any warrants that he had?
Yeah, I believe he had a felony probation and parole warrant out.
And they informed you of that?
Yes.
So, but at that point, the defendant was in your squad, about to be transported to Aurora for the field sobriety tests?
Correct.
Okay. And then after you ran him and learned that, what happened after that?
Then I transported him to Aurora for the SFSTs.
Okay. Do you recall before leaving this scene and going to Aurora, did you actually look in the defendant's vehicle to see any of the drugs?
Yes, Officer Delsart showed me.
What did he show you?
He showed me there was a coffee mug, like a travel carrier, in the center console area in the cup holder. Inside of that, I believe it was a gray mug, was a decent sized rock of what we believe to be crystal meth.
Did you see any cash in the vehicle?
Yeah, there was a wad of cash. I'm not sure how much it was, but
And where was that in the vehicle?
I believe it was near the center console area, but I don't recall exactly where it was.
If you had documented that, would it help to refresh your recollection if you could see your report?
Yes,
Okay. Do you have your report in front of you or near you?
I do.
Okay. And you also received the email that it has been marked exhibit number 1?
Yes.
Your Honor, I would just ask if Officer Coron could view what's been marked as exhibit number 1, her report, to see if that refreshes her recollection.
You're just asking for me to instruct her to do that?
Yes. Normally, if I were in the courtroom, I'd, ask to show her that. So
Yes.
if she could, okay,
Yes, the witness can review the exhibit to refresh her recollection.
okay. So if you just take a moment and I guess look at that, what's been marked with the clerk as exhibit 1. Is that your report?
Yes, I have it on my phone.
Okay. And how many pages is it?
I believe it's 2.
And just looking at the first page, probably the 7th paragraph down, does that refresh your recollection as to where the cash was in the defendant's vehicle?
Yes, it was located on the front seat.
And had there been any other occupants of the vehicle when you made contact with the defendant?
No.
All right, so after you saw that, what did you do?
Probably talked to Officer Delser. I don't know exactly what I did. He ended up calling a supervisor to talk to them about that. And then I went back to my squad to transfer him to Aurora.
And that was for the field sobriety tests.
Correct.
And then when you got to the hospital, what happened there?
I asked him if he wanted to do the field sobriety testing. He was hesitant. I told him it was his right if he wanted to do them or not. And he eventually said he did not want to do them.
Okay. And then do you know whether he agreed to submit to a PBT?
He did.
And do you know where the results of that?
It was all zeros.
And at some point, though, did you place him under arrest for operating while under the influence of a controlled substance?
I arrested him for just the OWI, operating while intoxicated, the second offense.
Okay. And when was that in conjunction with everything that's going on?
I believe it was after he submitted the PBT.
Okay. And did you did he agree to submit to a blood draw?
Yes.
Okay. Your Honor, if I could just confer with Attorney Malos for a minute. Corey, are you challenging that part of it?
No,
Okay.
I think probably like the first 5 minutes roughly of the stop.
The first 5 minutes
But
before?
basically before the transport, whether there was essentially like a de facto arrest or whether he would have been in custody for the purpose of Miranda.
Okay. So, thank you. Thank you, Judge. Getting just back to my questions for Officer Coron then. Did the defendant submit to a blood draw then?
Yes.
Okay. And at some point, did you fill out the alcohol and drug influence report.
Yes.
Did you, while filling that out, read the defendant his Miranda rights?
Yes.
And did he indicate whether or not he wanted to answer questions or not?
Correct. He chose not to answer questions.
All right, and then this all occurred at Aurora Hospital, correct?
Yes.
And after the defendant said he did not want to answer any questions, what did you do?
I wrote refused on the alcohol drug report on the bottom of it, and then proceeded to get him ready to take him to the jail.
And before you took him to the jail, did you bring him back to the Green Bay Police Department?
Yes.
Okay, and what was the reason for that?
So Officer Delsart could question him about the money and the drugs in the vehicle.
All right, and that was the asset, the civil asset forfeiture
Yes.
for the cash?
Correct.
Okay, so you brought him, the defendant, back to the Green Bay Police Department. What happened there?
I brought him into an interview room, started the recording, and Officer Delsart went in to speak with him.
Did you also assist Officer Delsart counting the money that you had seen on the front seat of the defendant's vehicle?
I'd have to look at my details.
Does that refresh your recollection as to how much cash he had?
Oh, sorry. Let me look. Yes. $1,325.
And then after he was done talking to Officer Delsart, did you bring him to the jail?
Yes.
Okay. And during your contact with the defendant, did your opinion that he was under the influence of an intoxicant or a drug ever change?
No.
All right, thank you. I have no other questions.
Attorney Malos?
Yes, Your Honor. Officer, you're not a drug recognition officer, are you?
No.
You were there as a officer checking on initially what was a community caretaker complaint.
Correct.
So you had no specific evidence that, in fact, Mr. Boltman was impaired prior to encountering him.
Not prior to encountering him.
You-
But
you found that
with the complaint of somebody passed out behind the wheel in the middle of the intersection at that time of night gives me an indication that they're either probably tired or they're probably under the influence of alcohol or drugs working the
let's
night.
talk about.
My experience with that.
Yeah, let's talk about that. You've been doing this for a couple of years.
Correct.
Right. So some people at night, that time of night, get really tired when driving.
Correct.
Yes. And
Yes.
unfortunately, people get in accidents that time of night because they're too tired, right?
Yes.
And you're aware that some people have sleep conditions, including narcolepsy, where they can fall asleep even in weird places.
Correct. But in my experience in 2 years, I've never had that happen. It's always been alcohol or drugs.
Yeah, and you probably don't document, specifically how many times you've come to, a road where a car was parked improperly and someone was passed out. True?
Correct.
So basically, you had several different possible hunches as to what could be going on, and one of those could be impairment. True?
Yes.
Now, you were approaching the vehicle from the front passenger side, right?
Yes.
You walked up the rear to the front passenger side. Okay.
Yep.
And your role was initially you opened the vehicle to check on Mr. Boltman to see if he was okay.
Yes.
And when you opened the door, you thought he was kind of sleepy or seemed to be hunched over.
Passed out or sleeping. Yes. Over. He was hunched over.
And you tried to get his attention by saying something.
I don't recall. I think I
But-
turned the vehicle off first before I tried to alert him.
So you remember turning the vehicle off, right?
Yes.
And primarily he was engaging the officer at the front driver's side. That'd be Officer Delsart.
Correct.
And Officer Delsart would be the one who was instructing him to step out of the vehicle.
Yes.
And Officer Delsart says something like, relax, I want to make sure there's nothing on you.
Yes.
And then Officer Delsart, in fact, opened the front driver's side door to essentially make it easier for Mr. Boltman to step out of the front passenger driver's seat.
Correct.
And when that was happening, you didn't see Mr. Boltman make any furtive movements with his hands.
I don't recall.
You would have put in your report if you saw any type of furtive movements that would have alerted you as an officer that your safety was at risk.
I believe when I told him to relax when he first woke up, he was startled to see us. So whether or not he moved his hands, sometimes I forget to put that in my report. But I don't recall whether or not he was moving around with his hands. Again, I told him to relax because obviously something happened where, again, I said he was startled to see us. Whether or not that was moving his hands around, I'm not sure.
Okay. So essentially he seemed startled as if he was waking up and he saw two police officers, and that seemed to make him somewhat surprised.
Yes.
And you didn't remember saying anything to Officer Delsart, such as, hey, do a pat down.
No.
Sure.
Officers do that for officer safety. I don't have to tell him to do that. He knows to do that.
And you're aware that the standard, though, is that there has to be reasonable suspicion that the person has some type of weapon or is a threat to law enforcement to do that, right?
And I'm going to make an objection. It's argumentative, calls for a legal conclusion under Terry. It's reasonable suspicion a crime is occurring, and whether the defendant may be armed.
In response, Judge,
Yes.
Part 3 of the attenuation analysis requires an evaluation of the flagrancy of the violation. So the officer's state of mind when compared to the actual violation in this case, I believe this would be a Dickerson, Minnesota violation. And if she doesn't know, that would make it less flagrant. If she does know and she did contrary to her training, that would make it more flagrant. So it is relevant for that purpose under attenuation.
And Your Honor, we're not conceding there was any violation on the part of police. This is an investigation into an OWI. And what you basically need is reasonable suspicion.
Attorney Melo, can you repeat the question again?
Yeah, so officer, you're aware based on your training that officers are only supposed to do pat downs if there's reasonable suspicion that the person presents a threat to law enforcement based on some specific facts or presents reasonable suspicion that the person has a weapon.
I'm not gonna allow the question. I think it is worded as being a legal conclusion, and with the officer making a legal judgment instead of just stating what she factually did during the incident and why she did it. So Attorney Melos, I'm gonna sustain the objection, and then you can try to reword the question if you're to get to the point that you're trying to make. Otherwise, move to a different question.
In response to the court's objection, officer, I want to ask you this. What do you recall from your training about when you're supposed to do a pat down of a suspect?
When we pull anyone out of the vehicle, we're patting them down to make sure they don't have any weapons on them that they can pull out and start to hurt us with. It's an officer safety issue.
In this case, you didn't see any weapon on Mr. Boltman's person or in his vicinity. True?
I did not, but weapons can be concealed very easily.
Nor did you.
Can I ask a clarifying question? So you did a pat down when he exited the vehicle?
Officer Delsart did the pat down when he exited the vehicle. Yes.
Was anything located on him?
No.
Well, then I don't see how that's relevant either then, Attorney Malos. They didn't even find anything of evidentiary value on him.
Well, it is relevant, Judge. And my analysis would be, if we're going to look in the first instance, and if I'm right, that there was a violation of law, then the state certainly can argue that there's that there's essentially no violation, and that falls under the attenuation analysis. So one of that three-part analysis is whether or not police in their collective behavior were flagrantly violating someone's rights. And I think the law is pretty clear that you can't pat someone down without reasonable suspicion. And the question is, was there a pattern of behavior that all suggests that there was a flagrant violation? Because essentially they just wanted to cut to the chase and get drugs, even though they weren't following the rules.
Okay, I understand the point now. I'll allow the questions and answers that have already been made, but I think that's the extent that I'm going to allow on that line of questioning.
Okay, so I want to talk to you, officer, about how the pat down physically happened. And I know you were not the one doing it; it was Officer Delsart.
Correct.
From your vantage point, could you see that Officer Delsart actually was putting his hands on Mr. Boltman as Mr. Boltman was physically trying to exit the front driver's seat?
Yes, that's normal procedure. It's called control.
But would it be fair to say that when someone's asked to step out of the vehicle, normally an officer won't put their hands on them immediately?
It depends on the situation.
And in fact, in this situation, the officer said, being Officer Delsart.
You're asking this witness about Officer Delsart's actions?
Yes.
And is the state planning to call Officer Delsart?
Yes, I was going to say, I think these questions are more appropriate for Officer Delsart, because this officer did not pat the defendant down, number one. And number two, she's already testified that nothing was found on the defendant. So I would just make an objection as to relevancy.
Okay.
I do agree with the court. I'll save for the purpose of economy. It might be relevant with another officer. So I'll just withdraw the question and ask different questions.
Okay, yeah, move on to the next subject. And then when Officer Delsart testifies, you can ask him about what he did.
Perfect. So, officer, when Officer Delsart was patting down Mr. Boltman, you essentially came over to the front driver's side to engage Mr. Boltman or assist Officer Delsart at that point, right?
Correct.
And you were able to participate in some of the dialogue that was occurring there?
I don't know if I said anything right there. When we got back to the front of my squad, then I started talking.
I think your testimony was there had been a point when Mr. Boltman's hands had been placed behind his back during the pat down, right?
Correct, which is standard practice.
And then would it be fair to say that you and Officer Delsart walked over to the front of the adjacent squad car with Mr. Boltman with his hands behind his back?
Correct.
And with respect to that, do you recall whether you said to Mr. Boltman what was going on, whether you guys were going to ask him some questions, or whether he was under arrest or just simply detained?
So when we got to the front of my squad, he still had his hands behind his back without anyone holding him, and he was facing the squad. Told him to turn around. I told him to relax and that he could put his hands down at the side, his side. And then, yes, we started asking him where he's the standard field or standard OWI questions. Where are you coming from? You have any alcohol or drugs on board? Those kind of questions.
So at that point, right around the front of the squad car is when you saw Officer Delsart release his grip on Mr. Boltman's hands.
Correct.
And that's when you said to Mr. Boltzmann, you can relax because he still was compliant and had his hands behind his back.
Correct. And he had been patted down, so we knew he didn't have any weapons on him. So
So you don't recall any clarification if either officer told him at that point, that he was detained or under arrest, or simply
he wasn't
being
told either.
Then there was some follow-up questions, mostly by Officer Delsart at that point.
It was both of us. I think he started the questioning, and then I asked him where he was coming from.
And then that's when he said Milwaukee.
Correct.
And the follow-up question related to, have you had alcohol or drugs tonight?
I think Officer Delsart asked first.
And there was a negative response on alcohol.
Correct.
And then the follow-up was on drugs, and Mr. Boltman said something to the effect of that he may have had drugs earlier.
Something along those lines. Some drugs, and then I asked him clarifying drugs, and he said yes.
But there was no commitment to when those drugs would have been consumed.
I don't believe so.
And I'll probably save some of the follow-up questions for Officer
Can you
Delsart.
can you repeat your answer? The court reporter didn't get it.
I said I believe so.
I'll save some of my questions for Officer Delsart on that topic, but in terms of from that point forward, a decision was made to do standardized field sobrieties.
Correct. Or transport him to the hospital to do them.
And we're talking about Aurora Hospital, about 2.9 miles away.
Correct.
And that was because of the weather.
Correct.
Was there a closer enclosed area where the field sobrieties could have been done safely?
It's standard for us to go to the hospitals. That's where we do them at, because then we have the cameras in the ambulance bay, and then we can turn our squads on. There's no closer hospital to Aurora.
Gotcha. What I'm driving at is the police department closer than the hospital?
No.
Now, just during that exchange, when you were explaining to Mr. Boltman that he was going to be transported for the field sobrieties, do you recall talking to Officer Delsart about whether Mr. Boltman would be handcuffed during that transport?
I believe so, yes.
And you said something to the fact that he might not be, if he's cooperative, and then Officer Delsart said that, in fact, he would be handcuffed.
Correct. I had only about a year on at that time, so I was listening to a senior officer.
That makes sense. Do you recall whether Officer Delsart would have gone to this front driver's seat to inspect the center console area before Mr. Boltman allegedly gave consent to search the vehicle?
Can you repeat the question?
Yeah, let's start with the basic question. I know there's been some question about consent, and that might be better addressed by Officer Delsart, what words were used, but do you remember words being used by Mr. Boltman that gave you the impression that he was agreeing to allow police to look inside his vehicle?
I don't recall the actual conversation. Officer Delsart would be better for that.
I'll save that for him. You do recall, though, that at some point there was a inquiry with dispatch about Mr. Boltman's status, and some information about probation was learned.
Correct.
would that be about 11 minutes or so into the traffic stop?
I believe so after looking at the CAD notes.
And so that would be long after the decision was made to put Mr. Boltman in the squad car to be transported to the hospital.
It wasn't long after. I believe I ran his name pretty much right after I seated him in the back of my squad.
Now, with respect to observations you'd made from the point of your initial contact at the front passenger seat all the way till you placed Mr. Boltman in the squad car, do you recall being able to observe his eyes?
Yes.
You had several good looks at him.
Yes.
And did you see that anything unusual about his pupils, constriction or dilation?
I don't recall. I just noticed they were bloodshot.
And that's not unusual for that time of night, true?
Correct.
And there's a myriad of reasons someone's eyes could be bloodshot, whether caffeine, sleep, lack of sleep, could be alcohol, could be a lot of chemical reasons.
Correct.
I think you might mention that Mr. Boltman's speech was slurred.
Yes.
What do you mean by that?
He was like slurring his words, which is common for people either on alcohol or drugs.
Now, when someone awakens from deep sleep, is it common in your experience that their speech will be unusual or appear as if it's slurred?
And I guess I'm going to object to that. I think it's probably beyond her qualifications. How would she know if people, when they awake from deep sleep, I mean, if they're, if their speech is slurred, she's not in the healthcare field or like a sleep lab.
And
Melos?
yeah, so Judge, this goes to the probative value, specifically, what the material observation, what weight it would have. And I think that the witness can always respond if she has enough lay experience or not to have any insight into that, because obviously officers are required to consider explanations for physical observations. And obviously they're not required to rule out innocent explanations. That's true. But it just helps give the court some weight based on their professional experience and or training about what the significance of the observation is.
Well, I do want her to be able to testify from her own personal experience from being a police officer. But the problem of generalizing that is that a police officer is usually making contact because of a complaint. So the likelihood that contacts that she has like this all are the same is high. But repeat the question and the officer can answer it if she can, based on her own personal experience.
Officer, do you have any professional experience or other personal experience about how someone emerging from a deep sleep might have or might not have speech abnormalities?
I would say personal experience. I don't believe people slur their speech when they wake up. When they wake up, they're tired and groggy, but not slurring their speech like somebody that's on alcohol or drugs.
And so if I played the video, would that show you the type of slurred speech that you heard?
Sure.
Okay. So permission not to use this as an exhibit, but for the purpose of refreshing recollection of a squad video.
What are you trying to accomplish with showing the squad video?
Well, we have a subjective opinion that Mr. Boltman's speech was slurred, and the witness obviously made that based on her on-scene recollection now that she's reconstructing of the event. And I'm going to show her the actual audio to help her refresh her recollection as to what Mr. Boltman sounded like that night.
I'm going to decline to allow you to do that. She's testified about her own personal observations already during the direct examination and during the cross. And I think this goes more into expert territory at that point if we're having her compare what her other personal observations are to the recording when she's already given her testimony about what she recalls. So I'm going to decline to allow you to do that.
So, officer, you've been trained under the NHTSA, National Highway Traffic Safety Administration course with your, I assume you're certified, right?
Yes,
And you were trained that, particularly in alcohol-related investigations, an individual may exhibit slurred speech as a clue of possible impairment.
be a cue, not a clue, but yes,
You, okay. So that would be your stop indicators, right?
correct.
Now, with respect to that, that training didn't include very specific drug-based cues, as you say, true? It was just alcohol.
Correct.
Have you taken any courses on specific drug-related signs of impairment?
No.
As a police officer?
No.
And when we talk about slurred speech, would it be fair to say that in some cases when individuals' speech is slurred, they can't even make comprehensible words? In other words, it's hard to even understand what they're saying.
Depends at what type of level of intoxication they're at. Everyone has a different slurred speech. They're not all the same.
That'd be an extreme level of intoxication, right?
Correct. If it's extremely slurred, yes, then they're either really high on drugs or really intoxicated.
At least in your experience, right?
Correct.
So when you say slurred speech, you're actually saying some sound that you're hearing that doesn't sound like normal tonality, right?
Correct.
And you don't know what Mr. Boltman's normal tonality is, true?
True.
So that night, it would be fair to say that when you were talking with Officer Delsart to Mr. Boltman, there was a several minute conversation before he was put in your squad car, right?
Correct.
And a lot of questions were given to Mr. Boltman by either you or Officer Delsart.
I wouldn't say a lot of questions, a few questions, yes.
And during that time, you were able to understand the words that Mr. Boltzmann used, true?
Correct.
And generally, you would say that the responses given by Mr. Boltzmann were responsive to the question asked, true?
Correct.
And you don't have enough training and experience based on the limited observations you made to have a firm belief that he was impaired by a specific substance, or there was some type of sleeper medical issues to the point when he was put in the squad car.
I believed he was under the influence of drugs at that point because he
You didn't,
to taking drugs.
but you didn't clarify with him when he would have taken those drugs, right?
Correct.
You didn't know if it was a long time ago or moments before the traffic stop.
Correct. But with being passed out at the intersection, it had to have been recently.
Well, let's talk about that briefly. No eyewitnesses to that, true?
To what?
To him being passed out. No one saw him as he was falling asleep, if he was taking drugs or not taking drugs.
Your Honor, I'm going to object. The conversation and the context of the conversation is, did you take drugs or alcohol tonight? There was no specific time, but there was reference to tonight. So I guess that just assumes facts not in evidence, that they didn't discuss a specific time frame where in fact, I believe they really did.
I don't remember that being the witness testimony tonight as the qualifier, and I would defer to whatever the court's notes are because I don't want to misrepresent testimony. If that is, that is. But I recall that there wasn't really a time frame, and now this officer is saying that she's 100% certain that drugs were consumed recently. So I'm trying to figure out what the basis is for that testimony.
Well, it is cross-examination. So I'll allow you to ask the questions, and the witness can answer them the best that you can. But can you repeat
So-
the question?
So what I'm saying, officer, would it be fair to say it's an assumption that you made that Mr. Boltzmann recently took drugs and that's why he was passed out at the front wheel, right?
That's my assumption, yes.
Because at least through the point that he was placed in the back of the squad car, well, let me take that back. At least at the point when you were talking to him in front of the squad car, there had been no observations by you or Officer Delsart of any specific controlled substance being in the vehicle.
Not in the vehicle, no.
And there was no odor particularized to Mr. Having a senior moment here, Boltman, or his vehicle that led you to believe that there was marijuana or any specific drug that had been consumed.
Correct.
That's all I have for right now.
ADA Potsky, anything additional?
Yes, on redirect. Just getting back to this point about a time frame, do you recall being present when Officer Delsart asked the defendant if he had any alcohol or drugs tonight?
Yes, I was standing right next to him.
And did you document that in your report as well?
I'd have to look. Yes, it says Officer Delsart asked if he had any alcohol or drugs tonight.
And then how did the defendant respond?
He said no to alcohol, but said some drugs.
And then did you document that you asked him if he had any drugs tonight?
I said, I asked him if he had any drugs, yep, tonight, and he eventually said yes.
And then did Officer Delsart follow up with if it was meth? And the defendant said yes.
Yes, correct.
And just as to the defendant's eyes, you testified that they were bloodshot. I think that's what you said.
Yeah, I just looked and I said glossy and bloodshot.
Okay, so were his eyes both glossy and bloodshot?
Correct.
And could you just briefly tell the court the training you did receive in detecting people who are under the influence of alcohol or drugs?
So the training I received a 1-week course while I was in the police academy at NWTC, strictly dedicated to standardized field sobriety test. And that includes all the HGN, the walk and turn, the one leg stand. And then that also includes looking at their eyes, and indicators are if they're glossy or bloodshot. That's usually a good indicator that they are under the influence of at least alcohol and or drugs.
And approximately how many other arrests have you made for people who are under the influence of an intoxicant or drugs?
I'm not sure. In my 2 years, I've been on quite a few OWI arrests, but my personal number, I don't know.
Okay. Was this your first OWI arrest?
No.
And when you gave the opinion that in response to Attorney Malos's questions that, well, could he have been tired? And that's why his eyes were bloodshot or glossy. Isn't it also true that they could be glossy or bloodshot if he were under the influence of alcohol or a drug?
Correct.
And when you give your opinion as to whether he's under the influence of alcohol or drugs, is it just one factor, or do you take all these factors or cues together?
All the factors together.
Okay. All right. Then thank you. I don't have any other questions.
Attorney Malos?
Yes. Officer, I just want to ask you about the significance of several things. First, let's talk about the dialogue between Officer Delsart and Mr. Boltman regarding drugs. Do you recall the exact words that were used that led you to believe that Mr. Bultman said that he had used meth that night?
Pull up my report. So I said in my report, I have Officer Delsart asked if he had any alcohol or drugs tonight. He said no to alcohol, but said some drugs. I asked him if he had any drugs tonight, and he eventually said yes. Officer Delsart asked him if it was meth, and he said yes.
So during that dialogue, you're basically paraphrasing things that were said.
Correct.
Okay, so starting with the first initial question, there was a question of, I think it was by Officer Delsart to Mr. Bultman, did you have any alcohol or drugs tonight?
Correct.
He said no, to alcohol, right?
I believe so, yes.
And then there was some follow-up about have you had drugs? And then something he said led you to believe that he was confirming that he had had drugs.
Correct.
There was no real time frame given as to when he would have had drugs.
Officer Delsart said if he asked if he had drugs tonight, that was the time frame. But no actual like specific time frame, just tonight.
And why I'm asking that, was there a specific follow-up question that Officer Delsart repeated himself? Have you had drugs tonight? Is that what you're saying?
I don't recall. I believe he just asked if he had drugs tonight, or drugs or alcohol, said no to alcohol, some drugs, and then I asked the follow-up question if he had drugs, and he said yes.
The testimony is getting pretty repetitive at this point, and she's testifying about what Officer Delsart even said. She's not even testifying about what she said. Attorney Malos, just so that you get what I'm sensing.
Sure, and this was brought up on redirect, so I'd like to just play the video, best available evidence with Officer Delsart. I think that'll clarify some things. And I'll skip the question.
If I can ask some questions of the witness, what happened to the vehicle at the end of the night? Do you have any idea?
It was towed.
And then I think you said it was a probation and parole warrant. Is that correct?
Correct.
Do you know what the charge he was on probation for?
I believe it was burglary or something along those lines.
Was it a felony or a misdemeanor?
It was a felony.
And that you're confident of?
Yes.
Okay. Anything additional on that point, Attorney Malos?
Not on that point. I have a separate related questions.
For a different witness?
No, for this witness, there were several points on redirect that were brought up.
Oh, I thought you were finished questioning. You were not finished questioning?
No, I'm going to move on with respect to the dialogue about using drugs that night.
Okay, then continue.
Thanks. So, Officer, you were also asked about the significance of glossy eyes and slurred speech, and you said that was part of your NHTSA training for cues of alcohol impairment, right?
Correct.
And you also said that's part of your NHTSA training for drug impairment as well, the cues for drug impairment?
Just the alcohol.
Just alcohol. Okay. And you haven't had an independent training that suggests that glossy-eyed or slurred glossy eyes or bloodshot eyes are indicators of drug use, true?
Did a little bit of training of drug use, but I can't recall whether or not those are indicators.
Last question, was there any reason based on what the judge said that officers would have had to go inside Mr. Bultman's vehicle before it was towed, just to assist with the towing?
It's normal for us to search a vehicle for an OWI arrest, but Officer Delsart, he gained consent anyways, so I believe that's why he went in there, is because he gained consent.
I'll follow up with him on those other issues, so that's all I have for now.
Then is the witness, anything else from the witness, ADA Potsky?
No, Your Honor, thank you.
Okay, then the witness is excused. And then Attorney Malos from just giving for a roadmap for the next two witnesses, the search for the vehicle, I mean, it seems pretty conclusive that that vehicle is going to be searched no matter what happened that night. Because, like I said earlier, because of the warrant, he's going to be arrested on the warrant. The vehicle is stuck in the middle of the road and they're going to tow it. And there's multiple avenues that the police can use to search that vehicle, either by consent, they could run a dog sniff around it, or they could do an inventory search when it's towed. So I think that vehicle is going to be searched no matter what happened that night because of the warrant.
We had testimony that wasn't discovered till 11 minutes into the video, and I appreciate the court saying, hey.
But that's because he gave consent before that, though, according to the witness.
According to the witness, it was really hard for me when I listened to the video to hear.
But that's the problem with the warrant, though. Even if the consent is unconstitutional, he's still going to be arrested on the warrant. The vehicle is still going to be inventoried search on when it's towed because it's in the middle of the roadway.
And I was of the opinion, and I don't know that there was a clear, explicit discussion of warrant, but I know when I listened to the audio of the squad about 11 minutes in, there was a comment about being on probation. I'm pretty sure that's when they were saying that the warrant was in effect. So to me, that really is the material question is if. And then
there's also an issue with the probation warrant also, because that reduces the burden of proof from probable cause to reasonable suspicion, I believe.
Yes, you're right. You're right. And Judge, I mean, I think this is partly me not briefing for the court that there was a warrant, and I completely overlooked in the complaint. And you're absolutely right to bring that to my attention as a significant issue. Just the way I'm reading the case you provided, it appears that there's still an attenuation analysis, and that would require us to look at, if the arrest was invalid or the intervention was invalid before the warrant was discovered, whether essentially it's cured because of the valid warrant. Let's just say 6 minutes in would be the de facto arrest, or 5 minutes in, and then 11 minutes in we've got the warrant. Does that cure it under the 3 attenuation factors? That's how I see it, and maybe I'm wrong because I haven't really read the case enough. But that's, in the limited reading, that's how I read the case.
Okay, so I
But
think
even,
ADA Patsky, if you had a comment.
I was just going to say, but even aside from all of this, you can't get away from the fact there's a warrant. He's getting arrested. He would be arrested on a felony warrant. The vehicle is now in the middle of the road. They're going to tow it and do an inventory search, anyway. So I guess, I don't know if any of it, if it really matters, but.
So I think I have heard enough on the search of the vehicle. That is part of the motion, correct, Attorney Malos?
Yes.
Okay, I'm going to deny the motion to suppress for searching the vehicle. I think Officer Corrin did satisfy the court that there was a valid search. There's a reduced standard of proof because of the felony probation warrant that reduces the search down to reasonable suspicion. So even if the consent that was given was unconstitutional, the burden for searching the vehicle would have only been reasonable suspicion. And even if they couldn't meet that, Mr. Bultman would have been taken into custody on the warrant. The officers would have been required to execute that warrant. And then we're stuck with a vehicle in the middle of the road with no one to drive it. And the officers would have towed the vehicle away and done an inventory search, or they would have been free to run a drug dog around the vehicle if they chose to do that. But the bottom line is they would have done an inventory search of the vehicle when it was towed. So I don't see a path for Mr. Bultman succeeding on suppressing the evidence that's in the vehicle. As to the statements that he made prior to the field sobriety tests, I will allow the defense to proceed on that. So when we call Officer Delsart, it's limited to the statements that he made to Officer Delsart. That's the only issue left in this motion. And I would like to hear from Officer Delsart on that aspect. Understood, ADA Potsky?
Yes, Your Honor, I'm just looking to see if then any statements to Officer Linsmeyer
Okay, I
Well-
didn't catch that there were statements to Officer Linsmeyer. If that's the case, we probably do need to hear from him too as well.
Right, it looks like there's just something post Miranda where the defendant was asking where he was. So I think that's the only, I'm just looking at the report here. Yeah, I think that's the only statement that Officer Linsmeyer was involved with. Right, and then statements from Officer Delsart before, I'm sorry, at what point, Judge, the vehicle search you said? Or no?
Well, let me ask the question a little bit more simply. Are there statements that Mr. Bultman is alleged to have made to Officer Delsart?
Yes.
Yes.
Are there statements that Mr. Bultman allegedly made to Officer Linsmeyer?
Yes.
And is the state seeking to introduce all of those statements at trial?
Yes, Your Honor.
Okay, then we would need to call both. If you're seeking to use them at trial, yes. But the issue is not, the motion issue is now narrowed to the statements that Mr. Bultman is alleged to have made to the two officers.
Okay.
Would you like Officer Delsart or Officer Linsmeyer?
I think Officer Linsmeyer will be shorter, so why don't we call him? I'll call him.
Okay, the only way I could figure out to do this was by closing the room. So we're
Sure.
gonna-
If you want to have Officer Delsart come up first, that's fine. It doesn't matter to me. Whatever's easier for the technology.
Okay, so we have Officer Delsart now. And Officer Corin, you are free to log off the Zoom and go to a different hearing or go to a different task.
I understand, Judge. I'm just sitting here listening, if that's okay.
Attorney ADA Potsky, any issue with that?
No, I wasn't planning on recalling her. And I guess there's no, well, the court sequestered the witnesses by putting them in a breakout room, correct?
Yeah, Officer Corin, I think just to play it safe, I think I would prefer if you remained sequestered and got off the hearing.
Okay, no problem.
Thank you.
Right, and then,
I have to get Officer Linsmeyer into a breakout room again. They both came out of here. Okay, Officer Linsmeyer is now in the breakout room. Officer Corin is now signed off. So the state can call the next witness.
all right, thank you. I will call Officer Delsart.
Officer Delsart, if you could please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
If you could please state your full name and spell it, please.
My full name is Scott Michael Delsart, SCOTTMICHAEL
Thank you. ADA Potsky, your witness.
All right, thank you. Judge, if maybe we could just clarify for the officer that our questions are now just going to be tailored to any conversation or you had with the defendant, any statements he made. Not the search of the vehicle anymore.
That is correct.
All right, so officer, would you please state your occupation?
I'm a patrol officer with the City of Green Bay Police Department.
How long have you worked there?
Just under 3 years.
And what are your duties?
Again, just any duty of a patrol officer, that's to conduct any investigations into crime, respond to calls that are dispatched, whether it be a civil matter to a disturbance to felonious crimes, to statements, speak with witnesses, apprehend suspects, to that effect.
All right. And then directing your attention to November 21st of 2019 at approximately 1:41 a.m., were you on duty?
I was.
And did you have occasion to make contact with a man named Jacob Bultman?
Yes.
And I guess for the record, the defense has stipulated to the identity of the defendant.
Yes.
Yeah.
that stipulation is in the record.
All right. So when you made contact with the defendant, do you recall where he was?
He was in a vehicle that was running. It was parked essentially in the middle of an intersection at the intersection of East Mason and Grandview in the city.
And when you made contact with him, did he make any comments about his whereabouts or knowing where he was?
I believe the first words I heard out of the defendant were something to the effect of, where am I, or not knowing where he was.
And did you have a discussion with him as to where he was or where he was coming from, that sort of thing?
I was on scene with Officer Coron, and between the two of us, we were discussing those kind of standard investigatory questions. At that point, we're investigating what we reasonably believe to be in OWI. So questions were asked by the both of us about, do you know where you are, where are you coming from? And I recall he responded once that he did not know where he was, and then I recall that he did respond at some point he was coming from Milwaukee.
And did you ask him whether he had used any alcohol or drugs that evening, that night?
Yes.
Okay. And why did you ask him that?
Essentially, for a few reasons, that's a standard question that I would ask anybody when I'm investigating a possible case of operating while intoxicated. But it's the totality of everything that led up to that believed me to kind of reasonably conclude that was likely the case, given that he had been passed out in his vehicle, that he had kind of been moving around. There were some indicators of meth use with his eyes, some jerkiness in his eyes. That just based on my training and experience, I believe to possibly lead drugs is the case.
And could you describe for the court the training you did receive in detecting anyone who may be under the influence of alcohol or drugs?
So my training would start with a several day section in the state law enforcement academy, then to also include further instruction in the City of Green Bay's Police Department mini academy, also with my field training program and my training officers when I wasn't training, several of which are FTOs, that field training officers that I've had are also SFST instructors and drug recognition experts.
And did you ask the defendant if he had used drugs or alcohol that night?
Yes.
And what did he tell you?
He said something to the effect that there was alcohol, but there had been some drugs, and then later clarifying that there had been some meth.
Did you ask him if he had used meth that night?
Yes.
And do you recall what he said?
Something to the effect of yes, that he had used meth.
Did he specify, how long ago other than that night?
I don't recall.
Okay. Did you ask him if there was anything in his vehicle, such as needles, that could hurt you?
Yes.
And what did he tell you?
I don't recall specifically. I had asked him that just because the vehicle obviously was going to need to be moved, and for the purposes of a tow truck driver getting into the vehicle to move it, that sort of thing, and reasonably believing that there had been meth use, which is often associated to needle use. I asked him more so for a safety thing. And it was during that point when he stated that I could check the vehicle to ensure that for everybody's safety.
Did you talk to him about whose vehicle it is that he had been driving?
Yes. At some point, he stated he was the registered owner. However, he later stated that he was not the registered owner, but that he informed me that he knew the owner and he had been driving it for a significant amount of time, had permission to use the vehicle, that it wasn't stolen or anything like that.
Okay. Did he say approximately how long he had been using or driving that vehicle?
I don't recall.
If you had documented that in your report, would it help to refresh your recollection?
Yes.
Okay, so what I've done is I had emailed the clerk your report marked Exhibit 3. Do you have that in front of you?
Yes, ma'am.
Right, Your Honor, I would just ask that the witness be allowed to view Exhibit 3 to refresh his recollection as to that conversation.
Let me just make sure Attorney Malos is tracking on which document. Exhibit 3. Attorney Malos, do you have Exhibit 3?
I do, Your Honor.
Okay, thank you. Then continue, ADA Potsky.
Okay, so Officer Delsart, do you have in front of you what I had marked Exhibit 3, which is your 2-page report?
Yes, ma'am.
Okay, and just looking at the first page, the third paragraph down, actually the last sentence, if you could just read that to yourself.
The vehicle was allowed to myself, or?
Just read it to yourself to see if that
Yep.
helps you remember what he said.
The vehicle was not his, but he stated that he knew the registered owner and had been using the vehicle for up to a year.
So reading that then helps you remember what he told you about, that he'd been using the car for a year?
Yes.
Okay. And then towards the end of your contact with the defendant, and after Officer Corin had read the defendant his Miranda rights, did you talk to him about the money, the civil asset forfeiture?
Yes, I did.
Okay. And what did he tell you about, did he tell you anything about the money? I think it was over $1,000, $1,325. Did he tell you anything about that?
I recall that he did not speak much about anything regarding the money or the methamphetamine that we located in his vehicle.
Okay. Did he admit that the money was even his? I'm sorry?
I don't recall if he admitted if the money was his or not.
Okay. If you had documented that in your report, would that, and reviewing your report, would that help you remember what he said?
Yes.
Okay. So if you could look at your report, which is Exhibit 3, bottom of the first page onto the top of the second page.
He stated that the money, he stated that he would not say that the money was his. Not interested in a voluntary transfer of assets of the money.
Okay, and he was not interested in the voluntary transfer, correct?
Yes. He was.
Okay. All right. Then that is all I have, Your Honor. Thank you.
Attorney Malos?
Just several questions. Officer, first, you said that there was some type of affirmative statement made by Mr. Boltman that he was on meth that night. In response to the question, have you had any drugs tonight?
Yes.
Okay, what exactly did Mr. Boltman say that led you to believe that he was admitting to being on meth?
Then I asked about alcohol or drugs, and when he stated no to alcohol, at some point he indicated drugs, and then it was clarified about meth. I believe I asked that just because of my suspicion of that, based on some observations. And then he said something to the effect of that there had been some meth use.
So, and that's your recollection of how the dialogue went, right?
Yes.
Okay. Now, second, there was some statement where you were asking him if there were needles inside the car, you recall, and he essentially made some statement that you construed as his consent or permission to enter the car.
Yes.
Do you remember what exactly he said?
Specifically, not word for word.
So you don't remember if he said you can go in the car, or you asked him a question and he responded by saying that's fine or okay or something to that effect?
Something along the lines of you can go check or that I had, without a doubt, he was saying that I could go into his vehicle to ensure there were no such things as needles or anything like that could be dangerous.
When you said, hey, are there any needles in your vehicle, did you say because you intended to search the vehicle and didn't want to get poked or anything?
Your Honor, I guess I'm going to make an objection. It's kind of beyond the scope of the issue.
Well, first
For
off,
us.
that was brought up on direct. Second, there's actually, I think it's Stacey Johnson, about how that question is framed, whether that's truly a freely and voluntary choice. So
But remember that the ruling is already that there's no avenue to succeed on suppressing the evidence located in the vehicle. So we are limited to the statements right now for the testimony. What is the statement that we're trying to get?
how the question was framed, whether or not there was a statement made by Officer Delser to Mr. Boltman that he was intending to search the vehicle, and that's why he wanted to know if there were any needles that could poke him.
Okay, the witness can testify what they recall that they said. I'll allow that. And that's the limit of what we're doing on this witness for this motion right now. Okay, so you can ask him what he said at that point, and the witness what he recalls.
My apologies. Officer Delser, what did you say when you made the comment to Mr. Boltman, do you have any needles? Did you, in full context, recall saying that you intended to search the vehicle? What words do you recall using?
I don't recall specifically how I worded.
Third thing I want to ask you about. So eventually you get back to the station and you get in the interview room with Mr. Boltman, right?
Yes.
Now, at that point, had Officer, I think it's Carone, mentioned that Mr. Boltman had been read his Miranda rights and he did not want to make a statement.
I recall that he had been read his Miranda rights.
You recall that he had been read his Miranda rights?
Can you repeat the answer? The court reporter wasn't able to hear it.
Your Honor, that I recall that he had been read his Miranda rights.
Did you have any conversation with Officer Carone whether Mr. Boltman intended to make a statement?
I don't recall.
Did you read Mr. Bultman his Miranda rights before you asked him about questions related to the money found in the vehicle?
I don't recall.
If I showed you the video, would that refresh your recollection?
Your Honor, I'd just make a objection. As to the money, it's an asset forfeiture, it's civil. Miranda would not even apply to that. So
Right.
relevance.
I guess the answer was that he was denying that the money was his. I think that was what the testimony was.
He would not say that the money was his.
But if it's going to be introduced by the state in the criminal portion of litigation, then I think it does pertain to Miranda, because the question is, if they're going to try and argue he possessed with intent to deliver and admit statements that they think are, essentially not unequivocal denials is to support inference of guilt, then I think we are dealing with this issue. But if they're not going to introduce the evidence, then I don't have to ask questions about it.
ADA Potsky?
Well, Your Honor, at this juncture, I mean, we're not at jury trial yet, but typically, any statements that the defendant made are admission by party opponent. And I guess that's why we're here asking for a ruling on that, whether, we use it at trial or not. I'm not going to commit that I'm going to actually use that statement, but I guess we'd need a ruling as if I could. And again, Miranda would not apply to any questioning about the money, which is part of the asset forfeiture.
I think Attorney Malos you're talking about the custodial interrogation aspect of it, right?
Yes.
Okay. So if the state is planning on using a statement as evidence against Mr. Bultman in the trial, this is a custodial interrogation analysis.
Correct, because it could result in an incriminating response, even if it's possibly used for two different purposes.
ADA Potsky?
Right, but again, the defendant, even though he was read his Miranda rights and didn't want to talk, that whole conversation about the denial that it was his money, Miranda wouldn't apply to that. Maybe I'm not seeing the point here. You don't even need Miranda to talk about that, the money.
I see what you mean. I'm not exactly sure what the law is, so that might require a brief if you want to use that answer in evidence.
Yeah. Well, I mean, he's denying it. So I guess,
there are still questions that you can ask somebody, even if they do not want to give a statement, like what's your name?
Right, the booking form, right. And it's kind of the same rule. I think I see the issue now. In the asset forfeiture, they can ask about it and it's used in the asset forfeiture trial portion. But I think now, if I'm understanding, defense is saying you can't use it in the criminal aspect. Is that what? Yeah.
Yes.
Well,
I think that's what he's saying.
Okay. I guess I'm not sure about that, but I can withdraw that because he's denying it. So it doesn't. I guess it doesn't matter. So
Okay.
I'll just withdraw that question about that part.
Okay, so the questions about the money after he was Mirandized, you're not going to enter as part of the criminal case. Where he denied.
Right. We won't refer to it at all.
Okay, understood, Attorney Malos. I think that addresses your concern then.
Yes, it does, and that's all I have.
Okay. Did you have any questions about anything else?
No, not with the scope of the court's ruling. If there's a motion for reconsideration because I've found something responsive to what's come up today, then we can deal with it later.
Okay. ADA Potsky? Any
No.
redirect?
No, Your Honor. Thank you.
Okay, then this witness is off the witness stand and you can sign off. And then I'll bring it, Officer Linsmeyer in. And I guess I have another question that's kind of related to what we're talking about while we're waiting for Officer Linsmeyer to come in, and that's if he's denying that the money is even his, why are we doing an asset forfeiture?
Well, I think he's,
Instead of the money
yeah.
being treated as abandoned property.
I suppose you could if that's what he wants to do. He would not say that the money was his. So he's not saying that the money is his and he's not saying that it isn't. So,
Okay, I suppose
you
that
know,
was, yeah,
yeah, the way that was worded, that's,
okay. Officer Linsmeyer, do we have you?
Yes, Your Honor.
Okay, if you're able to turn your video on, now we can see you. If you could please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And if you could please state and spell your name.
Officer Paul Linsmeyer, Linsmeyer.
And Mr. Bultman walked away from the camera feed. We have been going in this hearing for 1 hour and 50 minutes now. So I hopefully the Ozaki County Jail can continue to accommodate us.
Your Honor, I was just going to excuse myself to use the bathroom real quick if I may.
Yes, you may, yes.
Thank you.
Okay, we'll take a break for Mr. Bultman to use the restroom.
Judge, while he's doing that, could I have a breakout room with Officer Linsmeyer?
Yes.
Judge, I have a 3:30 call, but maybe it won't be that much longer.
No, I'll just confirm if I actually need Officer Linsmeyer.
Okay.
Except I don't have the breakout room.
Did I send him there? Okay, did you
Oh.
get the indicator?
Yes, now I just,
Okay, ADA Potsky and Officer Linsmeyer are talking in the breakout room. And we'll go off the record until the parties are back.
Sounds good.
We'll wait for Mr. Bultman to come back before we go back on the record.
okay.
Okay, we have Mr. Bultman back now. Attorney Malos, do we still have you? Okay, we have Attorney Malos, we have ADA Potsky. ADA Potsky, how would you like to proceed at this point?
I will call Officer Linsmeyer briefly.
Okay, I think we swore him in, but we'll just swear him in again. If you could please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
If you could please state your name and spell it.
Officer Linsmeyer, Linsmeyer.
And what is your first name?
Paul, Paul.
Thank you. ADA Potsky.
Thank you. What is your occupation?
I'm a patrol officer for the city of Green Bay.
How long have you been so employed?
For the city of Green Bay, 3 years with a total of 5 years.
Okay, so before Green Bay, where were you working?
The city of Tucson.
And directing your attention to November 21st, 2019, did you have any contact with a person named Jacob Bultman?
Yes.
And do you recall what you talked about or what happened?
I just remember I read him the informing the accused form and stood by while the legal blood draw was done there at Aurora Hospital. And while I was there, the defendant asked me where he was, and I advised him that he was in the city of Green Bay.
Okay. Thank you. No other questions.
Attorney Malos, any questions?
No, Your Honor.
Then that's all for it. Officer Linsmeyer, you can sign off.
And I have no other witnesses.
Attorney Malos, any witnesses on your end?
No, Your Honor.
Then what's the state's argument?
Well, Your Honor, as to the defendant's statements, I would ask that they all be admissible with the exception of the statement given to Officer Delsart at the end, which was post Miranda, that he would not say that the money was his and was not interested in a voluntary transfer of assets. All of the statements before that were pre-Miranda, I would argue that he was not in custody at the time. He spoke with Officer Corin as well as Officer Delsart on scene. And as to Officer Linsmeyer's testimony that the defendant had asked where he was, and Officer Linsmeyer said Green Bay, that was not in response to any questioning. So for those reasons, I would ask that the court rule that the defendant's statements are admissible.
Attorney Malos?
Your Honor, I'm just arguing that the point of custody occurred earlier than the state would argue. What we have is this: the essential facts are that on the night of the incident, there was a response to the call from a caretaker caller. Police came. One police officer, Officer Delsart, was at the front driver's seat. Officer Caron was at the front passenger's seat. She turned off the car. Officer Delsart told Mr. Bultman to come out of the car. He cooperated. Officer Delsart further basically took hold of Mr. Bultman and manipulated him to put his hands behind his back, did a pat-down search, escorted him to the front of the squad car without explaining whether he was in custody or not. He all the while was, he had his hands restrained behind his back to the point where the officers had to tell him at that point, when his hands were still behind his back, once Officer Delsart let go of his hands, that he could relax. He at that point was confronted by two patrol officers who were questioning him about what had happened that night. He was asked, obviously, incriminating questions. Our argument would be that at the time of the actual physical restraint, where he was led from one car to the other, hands behind his back, patted down, that a person in his position under an objective test would have believed that their freedom to leave was equivalent to a formal arrest. because it was physical restraint, hands behind his back, patted down. The question here also is interrogation. And I suppose before we get there, finally, I think we have no dispute from the testimony that Mr. Boltman was also handcuffed pursuant to the directive of Officer Delsart. Before he was put in the squad car, there was no, again, clarification as to, that he was not under arrest, that this handcuffing was simply for officer transport safety. So a reasonable person, at least at that point too, 4 or 5 minutes into the stop, would also believe that he was in custody at the time. So then the question too is interrogation. From that point forward, we would argue that from that moment up until the time when the Miranda was formally read, any questions by the officers that were incriminating in nature, which included what do you have, what is in the car, things of that nature, would be expressed questioning designed to eliminate incriminating responses, and that evidence would be suppressed. I suppose really once the questions were read for Miranda, really it doesn't matter as much from that point forward, because I think that sounds like that was done properly at that point, and it sounds like there was an election not to make any statements.
And Your Honor, it's the state's position that the defendant was not in custody at the scene. He was detained while the officers were conducting their investigation into the OWI. And the officers are perfectly well within their rights to do that. I don't think, so any statements on scene about him using drugs and meth, I would argue that they should be admissible because he was not in custody. Again, he was detained. I don't believe there were any questions in the squad car after he was handcuffed. And then at the hospital, though, just trying to see, I think that was post Miranda. Yeah, that was post Miranda. That was his statement was a question. It wasn't a response to any interrogation on the part of Officer Linsmeyer. Thank you.
Thank you. I'm going to allow the statements except for the 2 post Miranda statements that were made about the money. First and foremost, this is late night, early morning hours. It's a parked car in the middle of the road on East Mason Street with the driver who appears to be passed out, according to the testimony, behind the wheel, slumped over. This is also consistent with what's reported earlier by citizens at a different location, even how the defendant looked. So this is a very, very dangerous situation that the officers are coming up on. I think there's clearly reasonable suspicion of a traffic offense, and then also a community caretaker function that the police are performing during this contact. And I think that is reasonable for the officers to remove Mr. Boltman from the vehicle to do what's an OWI type investigation. And the line of questioning seems pretty routine for an OWI type investigation. The officers clearly have a suspicion that he has used drugs just because of his the condition they found him in, and his physical appearance and mannerisms. And the questioning seems related to the purpose of that investigation, and the purpose of a traffic stop being, where did you come from? Did you use any drugs tonight? Have you used any alcohol tonight? Those all seem like very common questions that officers can ask during an investigation into a possible OWI. I'm finding that he was not in custody for Miranda purposes at the time that he made those statements in this case. There was even the testimony, I think it was by Officer Corin, that he had put his hands behind his back, but he wasn't even required to because he wasn't handcuffed. And they told him that he could relax and that he did not need to have his hands behind his back because they did not want to handcuff him at that time. So I think when all of the facts are considered that were testified about here today, that the statements are admissible and he was not in custody at the time that he made them. So that's the ruling of the court at this point. I think that we have to schedule the case. Attorney Melos, are you requesting a status conference to talk to your client about where the case is at now, or a final conference and jury trial date?
He wants to set it for jury trial.
The first date we would have available would be Wednesday, March 24th. And then from that date, every 2 weeks on Wednesday. So the next one would be April 7th, April 21st, May 5th.
March 24th works great, actually.
You know, there's that speedy trial on that wire case, so I don't know if we'll be up for this one.
Which one is that?
That's that Stormwind Killer. He has 4 files.
I actually don't
I'm
have.
sorry, 3 files. Mr. Killer has 3 files. Maybe he didn't have a speedy. I don't know. I thought he did.
So it may not be the #1 priority case on that date, Attorney Melos. That also doesn't mean that that other case is going to not be resolved and taken off the jury trial calendar. Did you want to keep it on that date, knowing all that?
If there's a cleaner date, we could go the following, I think 2 weeks, you said April 7th.
Let's take a look at what's on the schedule that day already. There are 6 cases scheduled. 3 of them are felonies, but I don't have any of those other 3 marked as in custody. So based on what's on the schedule now, it probably would be the top priority.
Yeah, let's just schedule it that date.
Okay, so Wednesday, April 7th. Jury selection would be Tuesday, April 6th at 1:30 at the KI Convention Center. And then let's have a final conference on Tuesday, March 23rd at 3 o'clock. Attorney Melos for the final
Yeah,
conference.
if you'll bear with me for one moment quick. March 23rd, 3 o'clock, right?
Yes.
I have a trial that day that's very unlikely to go, so I can just schedule it.
We can schedule it or can't?
But yeah, I'd be in favor of scheduling it.
Okay. Tuesday, March 23rd at 3 o'clock for the final conference. Anything additional from the state?
No, Your Honor, thank you.
Attorney Melos, do you know if your client will still be in Ozaukee County on that date or not?
Mr. Bultman, you can just answer this question yes or no. Do you know?
I do not know. I don't.
Okay. Then we'll, if Attorney Melos, we could just try to keep track of it if he's moved.
And then I'll check in the week before, and Your Honor, I assume you want motions eliminated just about a week out before, or do you want them with more notice than that before the pretrial?
Well, if it stays on the trial calendar on March 23rd, jury instructions, verdict forms, and witness list would be due March 26th, so that Friday, if they haven't been filed already. And then how about motions in limine due Friday, March 12th?
Sounds great.
And then anything additional to address today, Attorney Malos?
No, Your Honor. Thank you.
Then bond continues, and that's all for today. Thank you.
Thank
Right.
you.
And then Judge, everything's by Zoom except for obviously the jury trial. So if he's moved from wherever he is, we'll obviously need to know, Corey, if you could just let us know.
Yeah, I'll check in again the week before. Maybe I should even check the day before or a couple days before too.
Okay. All right. Thank you.
Thank you.
Thank you.